This presentation is on annual reviews and the client servicing side of compliance. To my immediate right is Pamela Pendrell. Pamela is the Chief Compliance Officer of GlobeFlex Capital, a registered investment advisor that serves institutional clients and is located in San Diego. She's been with the firm since 2004 and held marketing and client service roles prior to shifting to compliance in 2013. Pam holds the IACCP certification, and she serves on the board of the Southern California Compliance Group, a regional group for investment advisor and broker-dealer compliance professionals. To my far right is Chris Stanley. Chris is the founding principal of Beach Street Legal, a law practice and compliance consultancy for investment advisors and financial planners. In this role, he provides legal advice and compliance counseling related to federal and state securities laws, SEC rules and regulations, investment compliance, RIA registration, M&A, and general corporate legal matters. Among the three of us, we have a pretty broad experience set with advisors from relatively small wealth managers up to the largest institutional advisors in the world. And what we're going to try to do is talk about some things in the compliance process and when you're dealing directly with the firm's clients that are consistent regardless of the size of the firm that you're in, and some that differ based on exactly what your size is and what the firm's clientele is. Before we start, from a quick show of hands, how many of you would characterize yourselves as institutional managers, and how many of you would characterize yourselves as managers for individuals? Let's start with institutional managers first, and individuals. Okay, so we've got more on the wealth management side, but we've definitely got some institutional representation here as well. The way we're going to go about doing this is breaking up the presentation really into four parts. And we're breaking it up into four parts that represent, from our view, the four touch points that compliance typically will have with the firm's clients. First, in the process of bringing the clients in, the marketing and sales process. Second, the process of client onboarding, looking at IMAs, looking at investment guidelines. We're clearly going to talk about the billing practices that you have for clients and what you can do in the onboarding process to make sure that that's done right, followed by client reporting, and hoping that we have time dealing with problems through the course of the client relationship, something that the compliance officer frequently needs to do. So I will start it out by turning it over to Chris to lead us through a discussion of the marketing and sales process and how the compliance officer can add value in the process.
Great, thanks, Mike. And as we were putting together the presentation, we realized it would be appropriate to think of all of our respective sections, but in particular, the marketing and sales side from a step-by-step framework process to help kind of lead ultimately up to the crescendo, the annual review. And the first part of that process, or the first part of the framework, is to really assess the universe of sales and marketing activities that your particular firm is engaged in, because it will differ from firm to firm. You'll see on the slides here we have a list of some things that might be in the universe of marketing and sales activity that could potentially be applicable to your firm. Old school print advertising, audio, podcasts, video advertising, perhaps online, social media to the extent you're getting more involved in that space, all the way down to use of solicitors, perhaps if you're using third parties to bring in clients to the firm. You're engaged in solicitation payments, perhaps to that referring party. And also to the extent that sales and marketing activity encapsulates certain specific nuances within the business itself. To the extent you have a private fund, to the extent you're engaged in lobbying activity, to the extent you're doing business overseas, all of these different aspects of the sales and marketing universe within your particular firm is important to understand as a baseline just to start the whole process off. And I think you can almost think of it as like a who, what, when, where, why, and how type of analysis to draw back to some old journalism classes I took from way long ago. But you essentially can look at it and say, okay, what sort of activities are we engaged in? Who is engaging in those activities? Business development employees, sales professionals, et cetera, within the firm, third-party solicitors, et cetera. When are they actually engaging in these processes, et cetera, and just really run through that type of analysis at the upfront depending on your particular firm. And then based on what specific sales and marketing activities are engaged in by your particular firm, we feel it's appropriate to next transition to really assessing the regulatory landscape and the particular rules and regulations that apply to your firm based on the sales and marketing activities. So, as a baseline, clearly we're going to be dealing with the anti-fraud provisions within Section 206. The advertising rule obviously is going to come into play, 206.4.1. But perhaps more importantly, the regulatory landscape is really going to get into more detail and more nuance when it comes to interpretive guidance and, most importantly, risk alerts. So, for example, if you're engaging in sales and marketing through the use of third-party solicitors, naturally the solicitor rule is going to come into play, and the recent SEC risk alert about cash solicitation activities, et cetera, and some of the areas for improvement, let's call them, for advisors will clearly be important for the firm to look at as well. To the extent you're engaged in lobbying activities, for example, to bring in new business, clearly state lobbying rules are going to come into play. To the extent that you're engaged in overseas activity, naturally overseas rules and regulations, regulatory frameworks are going to come in play as well. So almost the way to think about it is, step one, doing that firm-based analysis and then mapping it to this right column and understanding the regulatory framework that you're going to be dealing with, and either adding those to your list for testing and feeding those into your annual compliance program review, or eliminating from the list to really narrow down the sales and marketing activities and correlated regulatory things you're going to be analyzing for purposes of testing and ongoing monitoring, and ultimately the annual review. And I think, too, it's important, especially from this right column, assessing the regulatory framework, to understand that one of the expectations for an annual review is to do an assessment of any regulatory developments over the course of the year that affect the firm, and then build those summaries into your annual compliance program review. So definitely good to kind of keep track of those throughout the year so you're not kind of backloading the whole annual review process and trying to think back, man, what rules, what developments, what best practices came out in February of last year that I now have to summarize and think about for purposes of the annual compliance review.
Chris, before I move the slide forward, I forgot at the very beginning to encourage you to ask questions. These sorts of panels work a lot better. They're much more engaging for everyone. If you ask questions as we go along, we can do that in one of two ways. The first is we have some people walking around with cards, and you can write your question on a card and deliver it to Lisa or someone else. But I think that our room is small enough here that if you're feeling courageous, you should just stand up and yell the question to us. You won't have a mic, we do, but we won't take offense if you yell very loud so that everybody can hear you. That's fun, so we should do that. I'm sorry, Chris, go ahead.
No, absolutely encourage, please. And actually, this is a prompt opportunity to switch to the next slide here, where we're talking about common areas of pushback. And, again, this is sort of the third step in the process, or third step to prepare for. We understand the universe of sales and marketing activity. We understand the appropriate regulatory framework to apply. Now it's time to actually implement the regulatory framework to your particular firm in the form of ongoing testing and monitoring and ultimately feeding into the annual compliance review. And we probably wouldn't be doing our jobs as chief compliance officers and compliance professionals if at least we weren't getting some pushback in certain areas of our suggested testing or our compliance infrastructure. And so this slide is really designed, and I particularly will encourage comments from Pam and Mike and their respective experiences as well, as far as what types of pushback to expect, but also how to overcome those areas of pushback when designing your compliance infrastructure. The first bullet point here, I think, can be summarized in terms of short-term pain, long-term gain. In my prior life, I was a CCO and GC as well, and the way that I would try to explain to business units or the business side of the firm is that, look, it's going to be much more painless to get me involved and get compliance involved earlier in the process as opposed to later. If I find out after the fact that the firm is engaged in some sort of marketing or sales practice, oftentimes it takes more time, energy, and effort to try to create a solution from that while the car is moving, as opposed to putting the tires on the car before you even start the trip. And so it will take some work, it will take some time at the outset to do that, but again, it's going to be that short-term pain, long-term gain type of mentality when it comes to getting compliance involved earlier in the process.
Chris, if I could jump in real quick.
Yes, please.
I'm sorry, Pamela. There's a give and take in this as well, right? You are not going to successfully get the marketing team involved early in the process unless they believe that you are acting in good faith to resolve the issues that they bring to you early in the process. Otherwise, especially in smaller firms, our experience has shown they will move forward, do what they want to do, and then you will be left to tell them no after the fact and worry about residual liability. In a couple slides, we're going to talk about content and some ways to find solutions for content rather than just saying no. But I want to flag this because it's the other side of the coin of asking marketing to be involved early. You have to give to get that engagement. And what you have to give is not saying no, or if you're saying no, to be able to articulate in a clear way why you're saying no and to come back with an alternative solution. And over time, those business teams, even ones that have a reputation for not listening to compliance, will be a lot more engaged with you if you go through that process rather than simply saying no without describing the reasons or providing an alternative solution.
I was going to make the same point.
Yeah, explaining why can go a very, very long way, and we'll actually kind of come full circle with that later in the presentation, but that's an excellent point.
Can I just, I'm not sure if you're going to be diving in specifically to rankings, or is that just in this overall discussion? Because I'm curious. I think the rankings are incredibly annoying. I think the SEC cares very much about them, and they should. What I'm curious about is when you have credible pubs like a Barron's or Forbes that are doing these rankings, and then you have other companies that are sort of pay to play, or other companies that have these algorithms where they're just yanking it from the ADV and it has nothing to do with anything else.
Yep.
We suffer the fool. I mean, shouldn't these publications and these people that are doing this have a better understanding of what we're up against when we're doing these types of things?
So a couple thoughts on that.
Yeah.
First, I commend you for standing up and asking a question.
Yes.
Thank you. Great job. Second, yeah, they should know what you're up against, but if they can sell their product and they're not targeting you for their product, right, they're targeting your colleagues, they'll continue doing it that way. And third, let's think about some solutions for ranking specifically, but if we could, I'd like to defer that for 2 pages until we talk about content, and we've made a note, we'll address rankings directly.
But however, I will say that the comment does lend itself nicely to the transitioning to the next bullet point in the sense that, other firms are doing XYZ sales marketing activity or what have you. Why can't we? And I've heard this myself, and it is an exceedingly frustrating comment to get for the simple reason that it sort of presumes that the other firm is doing it the right way and is compliant and has gone through the appropriate process to make sure that they are above board in their particular practices. Maybe they are, maybe they're not. However, there's always a backstory at a particular firm as to how they got comfortable engaging in a particular activity, and each firm's individual profile will differ, which may or may not have justified why they are engaging in that activity. And maybe they've engaged a firm like K&L Gates and Mike to say, yes, you can engage in this particular activity based on your firm's specific facts. However, each firm's specific facts are different. And so I think, to Mike's earlier point, the particular way to approach this, or at least the way that I've approached it in the past, is to understand exactly, to the extent possible, based on public information, what the other firm is doing, how they've gotten comfortable with it, see if it can potentially apply to your firm, and make a decision one way or the other. But the initial pushback I usually offer is to say, look, this assumes that they're going about it the right way. I've encountered situations where another firm is doing something publicly which I've just personally disagreed with. So I think it's a common pushback item, but one that is at least hopefully partially addressed by some of those comments, and by taking the time to really understand what other firms are doing in the space, competitive intelligence, if you will.
Yeah, and speaking from personal experience, oftentimes, someone's gotten a hold of a presentation page, right?
Mm-hmm.
And they don't have the whole book. They don't know much about the firm other than they're a competitor. And so I'll go and pull the ADV and figure out, well, maybe they're a dual registrant. Maybe, there's some nuance that the salesperson just hasn't contemplated that would explain why they, can do it and we can't. there have been at least one occasion where I've called a CCO at the other organization and said, could you walk me through, sales is waving something in my face, and I'd like to understand sort of your posture and how you got here.
Yeah.
Excellent point.
2 out of 3 times, the other firm is a broker-dealer and you're an investment advisor, and the third time, the page was not supposed to be made public.
Yeah.
And then there's a very small residual for which there's a more complicated answer.
Yes. Yeah, there's always, yes, please.
So for those who didn't hear, there was a request for one example, when a common example for a situation where another firm is doing something, but you can't do the same thing, and why is it? What's one example to? And I think your question was, you want the credibility, right, to show your people that you know these circumstances. One example that comes to mind for me is client testimonials. Okay, if you are an investment advisor, your ability to present in your advertisements client testimonials is very limited, right? And you can show some representative clients pursuant to no action relief, but you can't actually include a testimonial. On the other hand, if your competitor is operating as a broker-dealer, right? The broker-dealer, Rule 2210 under FINRA is not going to prohibit, or not prohibit on an absolute basis, the presentation of customer testimonials, okay? And there are circumstances where the same testimonial would be permissible for a broker-dealer to say that an investment advisor couldn't. That's the type of situation. Now, I don't know, and you don't know what the question's going to be that you get, right? So it's a little bit difficult to project.
Well, if you can say one example, then I probably for this specific situation, I don't know for sure. I can find it out. But in our case, we can't do that. That's my knowledge. I can find out why.
And you said something that I think was a very important point, and I think the response is, I don't know, but I'm going to find out. That is an excellent response, because I think sometimes where we can potentially get into trouble is by saying we do know and it's just no, we can't do it. But saying I don't know the answer, but let me find out, I think is an excellent way to demonstrate that, hey, I care about at least trying to find a solution and seeing if there's some sort of workable way we can accomplish the goal. So that particular messaging is very prudent in my opinion.
Right.
So in the sake of time, I'm going to keep moving on here. Just one more comment I'll make on this particular slide. Social media without guardrails, and really this can apply to any new sales or marketing activity without guardrails, but it's the cake and eat it too type of mentality, where the firm wants to engage in some sort of activity but doesn't want to go through the process of actually doing the things from the compliance perspective that rules, regulations, no action letters, et cetera, require. And so social media was one example that we came up with where it wasn't too long ago before everybody was saying, oh, we need to get on the Facebook, we need to get on the LinkedIn, we need to get on the Twitter, et cetera, but they didn't realize that there's archiving responsibilities, there's testing responsibilities, there's going to be a lot of infrastructure and, frankly, cost that goes into this whole build out of social media. Are you as a firm willing to go down that route of building this infrastructure? If the answer is yes, then great, let's go. But if you're not willing to put in the time, energy, and resources to appropriately build out a new sales and marketing effort, then you're not really giving us much to work with from a compliance program. So with that, Mike, I want to keep us moving along, and we'll go to the next slide here. So here, as far as this particular slide, we're really going to dive into some of the testing, the monitoring, and how that ultimately feeds into the annual report. Again, I will strongly encourage Mike and Pam to jump in here. But just a couple examples from a sales and marketing perspective of things that you can do throughout the year to demonstrate compliance testing. I will start off by giving one of my favorite, albeit somewhat controversial, things to do from a compliance testing perspective, and that is to follow the money. Look at the financial statements. Look in particular at where money is going, who is being paid for what. If you're able to look at a firm's financial statements, and in particular accounts payable or some sort of other financial statement that demonstrates where credit card transactions are going, where money is being wired out, et cetera, that might uncover opportunities to see, for example, are there third parties that are being paid cash solicitation fees? Is there a large credit card transaction to LinkedIn Business because you're about to engage in a LinkedIn marketing campaign that you may or may not have known about? And so following the money, I think, is a great opportunity to see where is the firm's money going from a sales and marketing perspective, and are you aware of all of those expenditures, not about the dollars and cents, but just from the principle of where the firm is spending its time from a sales and marketing perspective. That can, again, lead you to focus your compliance efforts or perhaps discover things that you may or may not have known about. So I personally am a fan of following the money and looking at the financial statements, but again, that's just one particular example there. Moving right along into communications and advertising, again, making sure that there's a process in place for pre-approval of particular marketing pieces, making sure that your archives are in order and you can readily test them to make sure that there is the appropriate compliance or approval, to make sure that the records are being kept for the stated period of time under the Advisors Act. And then in particular, making sure that there's, especially for larger firms, making sure that there's a process in place for potentially business line approvals before it even gets to compliance. And I think that helps really get the firm involved earlier in the process as opposed to later. But hopefully it will help shrink down the amount of testing that you have to do if there's a frontline review being done before it even comes across your desk. And I think the last point I just wanted to make on this slide before Pam and Mike have any sort of comments is the ADV review process that I'm sure a lot of folks are still working on at this point in time right now. But this is a really excellent opportunity to bring in the firm for a collaborative effort. And you can almost sort of count it as a compliance meeting because the Form ADV is, in my opinion, the most important document for a registered investment advisor. A, for the SEC, B, for the investing public, and C, because it is ostensibly supposed to explain the sales and marketing activities, at least at a high level, you are engaged in, but perhaps more importantly, the conflicts of interest that arise from such activities. And it's ultimately those conflicts of interest that will trigger or cause you to engage in certain compliance testing activities and I think dictate the points of emphasis in your compliance review. So to the extent that you can really spend some time with your business folks on the ADV to understand, hey, these particular conflicts are explained in our ADV, but does this represent, the current sales and marketing activity that we're engaged in or not? Are there things missing in here that we need to input? So that document I really recommend spending a whole lot of time on.
Chris, let me ask you before
Yep.
we pass on from this slide. You've talked about a collaborative process to generate materials.
Mm-hmm.
We've talked about a good process for testing marketing materials. This is a panel, at least in part, about the annual review process.
Yep.
To what extent is it market practice or expected by the regulators that discussion of your marketing activities would be included in the annual review, and what would that discussion typically look like in your experience?
Absolutely. So, I think it'll depend on the nature and extent of the sales and marketing activity that your firm is engaged in. So if it's very limited, then perhaps by correlation, it would be addressed in a very limited fashion, if at all, in your annual compliance or program review and testing. If you have, for the first time, maybe ventured into the scary world of social media, that is an appropriate point of emphasis for testing throughout the year that ultimately feeds into your annual compliance program. So it's really going to be firm dependent, but I would venture to say that things that are new, like a social media rollout, things that you spend a lot of time on. For example, if the firm is engaged, a wide range of solicitors across the country, that's going to be a point of emphasis. So it really is going to be tailored based on that first step that we talked about on the first slide.
Okay. Well, hey, that's a good transition to our next slide.
Absolutely.
Talk about some practical solutions, kind of to the point of the question up here. How do we get past no is really what this slide is about. And we've identified some common areas where compliance officers typically feel like they need to say no. But there can be some solutions to those problems that, in my experience, the business side will adopt if you present it in the right way.
Yep, absolutely. And I think this actually kind of goes back to one of my earlier comments about, the cake and eat it too comment about, and also frankly explaining the why. And I think social media is an apt opportunity or an apt representation of a larger issue that some firms might face. So from the business side, we want to be on social media. Okay, that's great. Let's talk through the fact that there are certain regulatory frameworks that apply here, advertising rule, SEC SEC risk alerts and recent years on this particular topic. We apply that, and then we understand, okay, based on your desire to get in these particular social media channels, here are the options for how we can comply with a new social media rollout. And I think, one of the suggestions on the page here is driving traffic through a corporate account, as opposed to having individual reps in the field with their own individual accounts that then must also be archived, presumably driving up costs, presumably driving up the testing that needs to be done, and presumably driving up just the amount of stuff that you are capturing in the firm. And there are trade-offs. And I think our job from the compliance perspective is to educate the business lines about those trade-offs and presenting them with the opportunity to make the ultimate decision. Our job may not be to make the ultimate decision in that regard, but our job is ultimately to provide that regulatory education, the pros and cons, laying the groundwork for what we need to do, and then allowing the firm to decide, yes, we are willing to accept this or not. So, again, I don't know if there's anything else from your perspective you wanted to jump in on that particular aspect,
Yeah.
especially given your CCO
I would
roles.
say the closeout on that is then, okay, once the business has decided how they're going to delve into this area, then we need a policy, its own policy, or we need to incorporate some of these procedures and protocols into, say, more of a broad marketing policy. But kind of closing the circle
Yep.
with documenting, okay, here's what we're going to do, here's what we're not, and here are the lanes that we need to stay in, because I find that sales individuals need to be reminded sometimes of the guardrails, as you
Right.
say. I think, to your point, things don't have to be so black and white. It's not, I want to use this slide. No, it's I want to use this slide. Well, okay, what exactly are you trying to impart with this slide? Explain it to me. Okay, well, we could make that same point if we remove some of this questionable content, or we add several lines of footnotes at the bottom, or maybe we together come up with a whole different way to present the same idea.
Right.
But this emphasis on compromise and collaboration, I think, goes such a long way. It should be a partnership to some extent, the
Right.
sales and the compliance.
And we've identified on this slide a couple common areas where it's not too tough relying on no action guidance to get outcomes that the business wants, just not necessarily in the way that they brought it to you the first time around, right? We want to show gross performance, and we want to show gross performance to individual investors, not big institutions, right? One answer is no, you got to show net. Another answer is, okay, well, let's think about this. If you're willing to show the net performance and the gross performance with equal prominence, and we can find a way to do that, then we can get you 90% of the way there. But I can't just let you show net, or I can't just let you show gross, and here's why, right? Another example is the past specific recommendations. We want to talk about our biggest trades from the prior quarter, right? Well, which ones? Well, no, actually, the ones that we like. Okay, so, hold on a second. We can't do that, but here's what I can do for you, right? We can rely on the Franklin No Action Letter to identify the five biggest, the five largest trades, as percent of NAV over the prior quarter. Maybe the biggest buys, maybe the biggest sells, maybe the biggest buys and sells. And from that universe of trades, you can discuss the reasoning behind those trades in your marketing materials, as long as you don't talk about whether they were profitable, right? There are a variety of solutions here. And when we talk about collaborating with the business side, that's what we're talking about, right? No is easy. Doing the work to find a solution is hard, but that's what's going to make you much more credible in the eyes of your colleagues and get to outcomes that you're both comfortable with.
Yeah, and I think, having a little faith in your colleagues too. They don't know the rules or necessarily your policies the way you do. They might read the advertising policy once a year when they have to attest to reading it. So it's not that they're, coming to you trying to do the impossible. They don't eat and breathe this material the way
Right.
that we do.
Absolutely.
So we've got a question. So the question is it precarious, is it dangerous to rely on no action letters, particularly in light of the chairman's recent statements that the staff does not make rules, we make rules, and no action letters don't create any binding obligations or binding risks. So my view is, in the advertising area, it's pretty safe to rely on no action letters, and here's why. if you read the rule itself, right, there are only a handful of common advertising practices that are actually expressly prohibited, okay? And we know what those are. Most importantly, we're looking for prohibitions on past specific recommendations and the prohibition on client testimonials, right? Everything related to performance, you won't find a mention of performance in the advertising rule at all, right? What happened is over time, between 1961 when the rule was passed and 1987 when the Clover Capital no action letter was issued, the staff had taken the position that performance must be misleading, right? It must be misleading for someone to see how you've done in the past. And then they said in 87, well, maybe that's not the position we want to take, and instituted these 14 elements of disclosure that you need to show performance. That's all a staff created concept in the first place, right? So that's one answer to your question. The other, maybe more practical answer to your question is across the decades, I'm not aware of a single enforcement action in which an advisor faithfully adhered to all the requirements of a no action letter and had that enforcement action brought against them. Practically speaking, they are not regulations, but you should be able to rely on them. And I regularly advise clients to rely on them.
Yeah.
Answer the question?
Yeah, and I mean, as long as you're not shoehorning and contorting and kind of, playing cute with the facts, I absolutely agree with Mike.
Yeah. But don't shoehorn and contort and play loose with the facts.
Yeah.
because experience has shown that OC does not like that.
Yeah.
And they really don't like it when you say, well, I relied on the no action letter. And they said, well, you relied on half of the no action letter, the half that doesn't protect investors.
Yeah.
That's not a good practice.
Yeah.
Another
Yes, please.
question. Okay, so the question is, how safe is it to apply the same logic to IM guidance updates? A form of guidance that's not no action relief, right? We're not entirely sure what type of guidance it is, right? I do apply the same logic. Now, that said, the staff, I think, I feel commendably, is advocating to the commission these days that some of this guide, if the commission's going to take the position, sensibly, that this should be regulation. We shouldn't have secret law in the investment management space, right? It shouldn't be a practice area filled with rumor and innuendo, right? So the staff wants to look to the commission to clarify a lot of these points, okay? And that's going to take time, and it may happen or it may not happen. I hope that some of the guidance that you see in IM guidance updates, particularly the 2014 IM guidance update on social media, may eventually be adopted by the commission in the form of either regulation or guidance that has the commission's imprimatur on it, right? If that happens, solves the problem. If it doesn't happen, I still advise clients to rely on it because much like performance, there's nothing in the advertising rule itself that expressly prohibits participation in social media platforms. And it's a bit of a step to interpret participation on a platform to be a form of client testimonial, right, in the first place. So it's pretty safe.
Yeah, I mean, in my opinion, if the SEC is taking the time to actually publish that, I mean, these things don't come out overnight. There's thought and energy, and there's talking to a lot of people. If they're going through that whole effort to publish something, there should be at least a reasonable expectation from their perspective that the industry is going to rely on it to a certain degree.
Mm-hmm.
Yeah.
Now, we've gone through more than half of our time talking about marketing, and I am inclined, because we put the slides together and other people have other sections to go through, we will be here to answer questions if you have specific questions after the presentation. Let's talk about the client onboarding process. And in the interest of time, I'll go through this pretty quickly and really hit on some key points. I think of this process, and I'm thinking about this section of the presentation, ultimately as an ounce of prevention, okay? This is an area where an ounce of prevention will save you from a lifetime of trouble if you do it right, okay? So what are our regulatory concerns? It's going to depend on the client, right? We look at the client we have and we need to ask ourselves, are there special concerns with this client that are not present with our other clients? For you institutional managers, is this our first or one of our few 40 Act sub-advisory clients? Is this an ERISA client, right? For the wealth managers, you need to ask yourself, is there something about this account that's going to impose on us different either eligibility limitations or compliance obligations that we don't have for our other clients? That's one step that you obviously need to take. Now, a couple steps, and people do take those steps. Now, some steps that people sometimes forget to take at the point of client onboarding. My God, clarity around billing practices. If you have not been examined for your billing practices already, there's a very good chance that you will be at some point in the coming couple of years. And every fact pattern that I see from clients, every fact pattern that I hear about from others in the market involves a failure at the time that the client was brought on board to ascertain whether what the IMA says corresponds to what the practices actually are. Now, it's going to be a lot of work, and there are a lot of firms right now that are going through the process of reconciling those differences. But from this point forward, my view is it's really not it can't be excused if you are letting your firm engage in practices that you have had over time that are inconsistent or directly, violate what you say you're going to be doing in terms of billing in the IMA. How do we solve that? You need to have clarity with the client. And I know that the investor relations people don't want you to talk to the client, and I know that they don't want to talk to the client about something that the client doesn't want to hear, but this is an area where it is worthwhile. If it's not crystal clear that your billing practice reconciles with what's written in the contract, this is a time to get clarity at the outset of the presentation. Inadvertent custody. One of the favorite topics at the IAA conference, and something that you can address pretty easily. Compliance or legal needs to be looking at these contracts when they come in. Within the checklist of things you're going to check, ascertain what the scope of your authority is to wire funds out of the client's account. Okay? If you're not familiar with it, there was a no action letter issued to the IAA in February of 2017. There was a corresponding IM guidance update. You should read them before the next time that you get a new IMA to determine whether or not you have the authority to transfer assets other than in connection with trading on client accounts. I won't spend a ton of time on this in the interest of time. You can talk to me or any IAA staffer about the importance of this issue, but it's something that you should look for at the point of client onboarding. OFAC and AML are pretty direct here. Now, we need to do all these things. How do we reconcile that with the business goals? And I think everybody has had the experience where you've got a client coming on board and you get the investment guidelines to review, or you get the contract to mark up, and you say, okay, here we've got 12 hours. We got to sign this tomorrow, right? Or maybe more reasonably, we've got 3 days, but we're going to lose them. We're going to lose them if this doesn't go smoothly, right? Oh, and by the way, because it's a large account, they have an MFN. So figure that out. Right, and there's a lot that needs to be done quickly here, and in the next slide or two, I'm going to give some advice as to how to kind of expedite your review process and distinguish the material things that you need to address prior to the time that the client comes on from the other more procedural things that you can do afterwards. But another point that we want to make here, or that we want to flag here, is the CCO's engagement in due diligence visits, right? And we'll address this a little bit further in later slides, but this is a little bit different than the other things we're talking about. And we want to highlight it because the due diligence visit, where the client is coming on site for you, is one of the rare opportunities for the CCO to engage in the enterprising side of the business, right? You get to do something different and you get to help the salespeople. We'll talk about that a little bit as well. So let's find some practical solutions. In my experience, when you're bringing clients on board, checklists really help. And I know that that's not an insightful thing to say, but here's a suggestion that you might find insightful. When you're putting together your checklist and trying to figure out what you want to look at as a client is being brought on board, my recommendation to advisors is that they start with their risk assessment. As CCOs, you're going to have a risk assessment, I hope. And if you walk down your risk assessment, you're going to find a corollary at just about every entry to a potential risk when you bring a client on board. So don't reinvent the wheel. Go to your risk assessment, find each area of risk that's at your firm, then figure out whether the new client introduces a new area of risk. Suddenly now we need to be worried about 40 Act portfolio compliance, right? Or this is our first retirement plan, oh geez, we're subject to ERISA, right? And it's a good way for the two things to work together. You will have an opportunity to identify the material risks in IMAs and investment guidelines and billing practices by looking to a risk assessment, assuming that it's done well. And it's also a process by which you will be able to ascertain whether there are new holes in your risk assessment as the new clients come on board. And I think that that's a very important process.
Yeah, I would also add, also thinking about your policies and procedures as they stand, and if any new elements that this client relationship is going to require you to revisit those policies and change them. For instance, we've had clients that want 10 years of record keeping. Oh, okay, well, we keep everything for 7 because we're registered in Canada and the US. So, now for this particular client, we need to put in procedures to keep things 3 more years potentially. So, every IMA introduces potentially some new procedural elements that you have to take into account, and you may need to edit your policies accordingly.
Right. And they often introduce ambiguities, as we noted before. Those can be ambiguities in terms of interpreting investment restrictions. Often they're ambiguities in terms of interpreting billing procedures. And what can happen, and what's happened at a lot of firms, is you let those ambiguities slip through the sieve at the outset. Mm-hmm. And they don't cause any problem for 6 years, right? And then on year 6, either you have the staff come in and ask you about the billing practice, or on year 6 you realize, oh geez, they interpreted no private placements to mean that we wouldn't buy any 144As for these, mm-hmm. right? Or you've got this ambiguity, and suddenly you're stricken with this potential liability that could have been very easily avoided if you spent the time to talk to the appropriate team internally and had, I hate to say it, the backbone to tell your people, we need to go to the client and resolve this ambiguity. Clients are accustomed to it, right? Your sales team doesn't want to approach them with this, but other salesmen are approaching them with this all the time, right? They want to know that you're doing it right. If you present it the right way, it works. Chris, I think you had a couple other thoughts on the due diligence visits and really how a CCO can add value at those at that point.
Yeah, and I think it's important not to sort of shy into the background or resist the opportunities to do that. I think it actually can be a benefit for winning business, et cetera, if there's a strong compliance presence, a strong CCO, et cetera, and you can demonstrate a strong infrastructure. I think perhaps where some of the challenge in the debate comes in is, okay, how much do you share, especially when it comes to like the annual report, for example. And I know Pam's smiling because we were talking before the presentation here about some of the various ways that you can go about it. A, sharing the whole thing. B, sharing a limited, truncated summary version of it, allowing folks to view it, but only on site. So, Pam, I know you have some thoughts on that particular aspect of it as well. Yeah,
with regard to due diligence visits, they really run the gamut within the institutional space, and that's the perspective that I'm speaking from. Some visitors just want to know that you carry out testing. Others want to know what you test, how frequently you test it, how you document it, what you report to management. Others may even want to see some of your testing files. I have not encountered that in some time. My suggestion would be to maybe show them something on screen, but don't start handing out testing documentation. Due diligence visits are your opportunity to demonstrate your value to both the visitor, whether it be a prospective client or an existing client, and to your colleagues. And in the institutional space these days, I don't think you can successfully win and retain business if you don't have successful due diligence processes. That means a really good questionnaire response and really showcasing your compliance program strength and comprehensiveness during the visit. And I have spent entire days in due diligence visits where my colleagues and or the visitor want me in every single session, and I am getting questions on trading and business continuity and cybersecurity and the proxy voting process and performance calculation. So it's really an opportunity to show your value to the organization. And I think it really builds a ton of credibility with your sales and client service peers when you help, achieve a successful due diligence day. Before we kind of move on to the annual review itself, do we want to address to the extent to which client onboarding should be articulated in client reviews?
You mean in annual reviews? Yeah.
Thank you.
Yeah. Most of my clients don't have a separate section around bringing new clients on board or their process for onboarding. And I think that's acceptable. A handful do, but I think what's really important is that if you onboard a client in a given year and that client introduces a new regulatory structure to you, it's very important to include that in the annual review and to talk about what you have done in order to be ready to adopt or to administer your obligations under that new structure. We saw in the 2019 exam priorities, we've heard verbally from many members of the staff lately that they have a concern around advisors that have not previously managed 40 Act products that are taking on 40 Act products, and they might not be familiar with the 40 Act and its requirements. That's one example where having an annual report, right, or a written annual review is going to, that discusses all of the steps that you took to ensure that you were ready to manage that 40 Act product, is going to put you in a very strong footing with OC staff if they come asking that particular question. Are you ready? Do you know what you're doing here? Oh yeah, we know what we're doing. Oh, by the way, look in our annual report where we talk for 2 pages about what it is we did to get ready. They're no longer going to view you as a high risk, right, if you do that.
And I think the same thing can be said. I mean, obviously, the staff just was specifically pointing to new managers of 40 Act funds, but to tie it back to sales marketing, if you've engaged a solicitor for the first time, if you've engaged in social media activity for the first time, that's an appropriate point to include in your annual report because, again, it introduces new risks, new processes, new policies and procedures, all of which would be appropriate, at least in that first year's annual compliance report.
So, again, let's move on because time is always tough.
Clock is ticking.
Pam, can you talk to us about the client reporting process?
Yes. So client reporting, we've successfully won the client, we've onboarded the client without a hitch, and now we're managing assets, and in a lot of ways, this is where kind of the real work begins. If you want to have a long-term relationship with the institution or the individual. I think firms vary. At some firms, client service and sales are handled by the same professionals. At other firms, they're two distinct departments. I think that there are challenges that are presented when client service is handled by salespeople because, of course, it's hard for them to take their sales hat off. And when you're operating under a contract and you're acting as a fiduciary, deliverables to clients are different than marketing pieces. And we have the regulatory concerns of, are we meeting all of our contractual obligations, and are we fully and fairly disclosing all material facts? Information presented to clients needs to be forthright. Don't be afraid of presenting the good and the bad and the ugly. And we'll touch on this a little later, but you're reporting both on their portfolio and the firm, the business, how you're doing. And they will ask potentially challenging questions, either during visits or in their, say, quarterly reporting template. So as far as the business goals go, back to our point earlier, we want to keep the client happy. Happy clients mean we're managing assets and we all have jobs. There is an element of speed that gets introduced, particularly if client service has, say, overcommitted on a deliverable. You may get reporting requests that come in ad hoc, and they may be highly nuanced with a tight turnaround time. So, here again, servicing your colleagues, you want to be adaptable and approachable and help them meet a tight deadline to the extent possible. That doesn't mean we forsake, thorough preparation and thorough review. We're not just going to slap a bunch of numbers on a page. And you may need to actually help client service develop the content. I do a lot of writing. It's remarkable, and outside of policy writing, whether it be for ongoing questionnaires, due diligence questionnaires, or ad hoc requests. There's a lot that client service, just doesn't understand maybe some of the specifics or the nuances, particularly if you have to get into describing violations, not necessarily just material violations of policies or your code. If you have to get into discussing cybersecurity and business continuity, they're going to need your help. And so to the extent that you can drop everything and help your colleagues deliver to the client in a timely manner and in a comprehensive fashion, I think that earns you a lot of points. You also are going to encounter times, or I at least have, where we need to politely push back. And this is something that client service really doesn't like to do. Often they will want me to be on the phone with them to the client to, have me deliver the sort of tricky message of, no, we're not going to give you what you've asked for. I mean, we recently had a client ask us how much we were paying a particular vendor every year. And we just felt that really wasn't any of their business. We didn't say it that way, but the client is not the regulator, and in some cases you need to work with client service to deliver not everything that the client wants, but in a professional and a kind way. I also find that clients will impose their risk perspective on you, so they will come in or ask questions coming from a place where they've decided that you have a risk, and you may see things differently. And that can make for interesting conversations in due diligence visits. Why aren't you testing this? Well, let me explain to you why. And again, these are conversations that the CCO or compliance professionals are going to have because client service, unless they're really, really knowledgeable about every particular nuance of your program, they're just not going to be able to speak to. I think that's kind of it here.
How do you feel about not providing clients with quarterly statements? We've had a lot of our wealth clients, so in our contracts originally, we did have an obligation to provide periodic statements, but over time, as they're getting them from their custodians, they're like, why are you sending me this stuff? I don't want it. And we're struggling with, should we amend our contract and now say we don't have to do it? Are the clients asking for that? Or it makes me a little bit nervous not to provide it. What do you feel about that?
I would make me nervous too. I would find a way to keep sending it. Maybe you can send it electronically so they can just delete it and you don't, have to kill a tree. I don't know if it's in your contract and you don't deliver, even if they told you not to. I would want an amendment. Yeah.
I've had clients ask that question and have had good luck allowing their clients to opt into a system where the reporting is made available through a client login on the website, but not actually delivered. Now, we don't have time to go into the old guidance about electronic delivery for SEC. Make sure you do it in accordance with that. But that's one solution where you're still making the information available, but not harassing them with the quarterly touch point.
I might actually take an opposite approach, and you may hate me for this, but a couple things come to mind. A, if they're getting it from the custodian and that's the information that they need, that's the regulatory requirement, then so be it. B, introducing an additional report imposes upon you a duty to make sure that it's accurate, correct, especially when it comes to things like performance and fees. And we all know how closely the SEC is paying attention to performance reporting and fees. And so to the extent that you don't have a robust infrastructure to make sure that the statements you're sending out are accurate with respect to performance and fees, it just adds an additional risk that may or may not be worth continuing, again, if the clients are not finding value in it. So for whatever 2 cents that's worth, just another counterpoint to consider.
I don't disagree with that. Whatever you give or make available should be right.
Right.
Yes.
Good point.
Else you have a problem.
Regardless
You
of
have
the
to do
vector
it.
you
Yeah.
use to get it there.
Yep.
Yeah.
Absolutely.
Just kind of closing out client reporting and tying this back to, one of our topics. The annual review report itself as a client reporting item. I have several clients that ask every year for a copy of our annual review report. They don't want to simply know that it's been done. They want to see the report. So I prepare 2 versions. I have my comprehensive version that I prepare for management. It goes into detail. I attach my risk matrix. I put findings from testing, itemized in there. I itemize immaterial violations as well if they were to occur, material violations. And then I have a pretty comprehensive conclusion where I talk about what we need to do in the next year for enhancement or improvement purposes. I also prepare an executive summary, which has some of the same content as far as changes that occurred in the business during the year and sort of our landscape at the end of the year. I would only articulate material violations, and I don't get into the results of testing. And my conclusion is generally that the program is adequate and effective. If there had been material issues that prompted us to identify serious areas for improvement, I would speak to that in the conclusion. I have not had any clients push back on receiving just the executive summary. I think that alone, it's 4 or 5 pages, that evidences a process and a methodology, and that we are taking 20647 seriously, and we are conducting a comprehensive review. Anything to add on that as far as?
I think we should probably get to the last section because some might say it's the most fun, and that's dealing with problems when they happen. Look, what are the regulatory concerns? It's in the nature of a problem that you don't know today what the problem tomorrow is going to be. So you've got to be ready to look to any number of sources of regulatory concerns. These are some of the most common ones, but it could be anything. And when a problem arises, I like to use trade errors as an example, but they're certainly not the exclusive problems faced by investment advisors. You've got, really, to my way of thinking, 2 things that you need to do. Number 1, solve the problem. But number 2, you need to solve the problem in a way that is acceptable to the business, and their interest in this is often not at odds with yours, but they don't look at problems the same way. I think you have some experience in this.
Yeah, I mean, this is a situation where you need everybody's input. Like, client service shouldn't be dealing with complaints or problems themselves. You need to maintain your business perspective. There's a difference between a regulatory obligation versus what you've committed to in a contract versus what may just be like ethically the right thing to do. So it's a matter of really good and quick communication, gathering your the relevant colleagues and the facts, fixing the problem, and then getting on the phone with the client, which is something that, of course, again, client service generally doesn't like to deliver bad news. And it may not be bad news, it may not be actual harm, but it may be, there was a breakdown and we bought a restricted stock, or we've gone over a parameter, or we've had a trade error. The less than rosy information is something that client service doesn't like to deliver. You're probably going to need to participate in the call or putting together a more formal communication if that's the case.
Client service is terrified of that call, but in my experience, the way that an advisor goes about resolving that error or resolving that problem usually is what the client is going to remember and is going to be how the client determines whether or not they want to stay on, rather than the error itself.
Yep.
And too often we see advisors through trying to be cute or not giving full information or only leaking out information. The client has to ask for more. That's what ultimately sours the relationship. And that can be a tough thing for the client service officer to understand. A lot of times, you as compliance officers need to be the person advocating that and making the point that it's not just the right thing to do as a fiduciary, it's the right thing to do to keep the client.
Right, and we're not the first manager who's made a mistake.
Particularly on the institutional
Right.
side,
We are human, and our clients know that, and,
It may seem counterintuitive, but perfection is somewhat suspicious, in my opinion. So,
And Chris, I think dealing with complaints is there are a lot of similarities there as well, right?
absolutely. And I mean, look, I think, at least in my experience, the way that a firm handles a client complaint or an issue speaks volumes to the longevity of the client relationship. Trying to sweep things under the rug, trying to minimize it, usually doesn't result in good outcomes. But acknowledging the error, owning the error, explaining to the client the steps taken to make sure that it doesn't happen again, those, I think, are what is really valued from the client's perspective. But again, the opposite approach and trying to paint this rosy picture as if nothing is ever going to happen bad ever is not going to be good in the long run.
Right. I'd like to make one more point. We're a little bit disjointed here on trade errors specifically. We have short time. Please remember to call your insurance carrier. Do not have a trade error, fail to call your insurance carrier, take responsibility for the trade error, discover that it's several $1 million of potential liability, only that you did not file a timely claim. So just please remember that. And let's, if we could, we're going to wrap up a little bit talking about identifying conflicts. And we weren't quite sure where to put it, but we wanted to share a couple of points of view. We've got just a minute to do this. Many compliance consultants out there in the market will tell you that having a list of your conflicts is a best practice and an expectation, and there's often a lot of pushback at firms, including from CCOs and general counsel, to that point. And in fact, I would say that whether or not maintaining a list of your conflicts ultimately is going to depend on what kind of firm you are, right? If you're a fairly simple firm that's fairly small, that doesn't have a lot of conflicts, you're going to know those conflicts. You can incorporate them into your annual review, incorporate them into your policies. As the complexity of what you do expands, typically with size and with diversity of clients, your conflicts can become a lot bigger. So, Pamela, what do you do at GlobeFlex?
I have a conflict matrix. So each year I go through, it articulates actual conflicts that do exist, and then potential conflicts, things that could arise in the course of our business managing assets for institutional investors. And then I have columns where I pair up, what's the disclosure that we already make and where do we make it? And, further to that, do we need to add something? Are we comfortable that this is really, there's not a lot of risk here? And what sort of mitigators do we have in place from a policies and procedures standpoint? I find it helpful, A, in prepping for ADV update, and B, if something does change during the year in your business, and you've already sort of have that in your matrix as a potential conflict, you've already identified it, that you don't already have disclosures per se, and it helps you kind of quickly understand, or me, what I'm going to need to do as far as writing or such.
And Chris, we'll wrap up by asking you. So that I think is representative of the institutional perspective on this.
Yep.
Your wealth management clients, how do they feel on this point?
So, by and large, obviously, I recommend to the extent feasible, reasonably tailored, et cetera, that you can have a conflicts of interest assessment or at least some sort of worksheet, great. But if you don't, you're not comfortable with it, whatever the case may be, at least get it right in your Form ADV Part 2A. The Form ADV Part 2A, obviously, you're supposed to have full and fair disclosure of all material conflicts of interest. It allows clients to give their informed consent to work with you, et cetera, et cetera. So really, if you don't have a separate document for conflicts, at least just hold up your ADV, use it with your sales folks, et cetera, and say, okay, here's the conflicts that we have identified here. Here's the ones that we're tracking. This is designed to really represent our business. Where are the gaps? Where are there other conflicts that we're not aware of, and how can we more fulsomely disclose this in our ADV? So again, if you don't have a separate document, at least for the love of God, get it right in your ADV. That's what your clients are looking at. Maybe that's more importantly what the SEC is looking at.
Okay, so we'll wrap up with that. I hope that you found this panel practical and actionable. Thank you.